Thanks. Thank you. I hope everyone can hear me okay, both here and in Dodge. As you heard, I'm going to talk about Daubert, which is sort of how we generally describe the expert witness standard, and that comes from a case that I think many of you would be aware of. But in a nutshell, what we're talking about today is how Wisconsin's expert witness statute has changed and how we are now what is known as a Daubert state, like many others in the country. And we'll go from there. It's been a few years since we've had the new statute, but I do think it's helpful to step back and sort of look at our old statute, and so I've projected on the screen here, and it reads that if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of opinion or otherwise. One thing I always want to stress when we talk about our statutory change to make us a Daubert state is that it was not a statutory change that removed anything from the statute. It didn't repeal the statute, and it certainly did not amend anything I've just shown you. What it did was add to the statute, and so we add at the end that if the testimony is based upon sufficient facts or data, the testimony is the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. So right now, without knowing any more or breaking up that statute beyond what you see on the screen, just remember that essentially all of the old case law is good to a point. It may not be good onto the ultimate admissibility, but if it addresses what kind of knowledge we're talking about, if we're talking about the ability to assist the trier of fact, if we're talking about qualifications, none of those have changed in Wisconsin law. And so this is a situation where I certainly believe that the old cases can still be very helpful to you. Although we've now had this as the statute for quite a few years, since 2011, it takes a while to get through the court system. So we don't have a wealth of cases and case law from Wisconsin. So you're going to use, if you confront this sort of challenge, a combination of our past laws, recognizing what they do and do not cover, coupled with out-of-jurisdiction cases, and you can usually find your answer. What we'll cover today is sort of the legal history of the statute, the new expert law in Wisconsin, and its implications to us. And what it really boils down to is those added elements I've talked about here, the qualifications, the research, and the application, the additional things that will have to now be shown that didn't have to be shown in the past. I think it's always helpful to kind of understand where we were to understand where we are. And if this statute looks very similar to the one I just showed you, it's because it essentially mirrors what we've covered in the state law here in Wisconsin. And this was the Federal Rule of Evidence 702 prior to 2000. Just like our statute had an addition made to it, an addition was made in 2000 to the Federal Rules of Evidence. And so you can see certainly some parallels and similarities to what I just covered a moment ago. It's that same sort of additional language that we had in the Wisconsin added more recently. What's worthwhile is looking at the Federal Rules of Evidence, because that can be a great resource to finding out what are the rules going to ultimately be in Wisconsin. And since the language is essentially identical, the federal rules provide good guidance. And so the committee notes of the rules explains that when it was amended, that would be the 2000 amendment, it was in response to Daubert and the cases applying it, including Kumho Tire, which is a case we'll talk about in a moment if you haven't already familiarized yourself with it. And what Daubert did was charge trial judges with the responsibility to act as gatekeepers to exclude unreliable expert testimony, which Kumho Tire clarified was not just limited to science, but also applicable to experts in general fields. One thing I think that often gets lost in this area of law is in Wisconsin we view Daubert as somehow being restrictive to expert witnesses coming in. And I often think it's helpful if you're confronted with a Daubert challenge to read, obviously, the Daubert case and understand the facts and what it did. Daubert was actually a minor child born with a serious birth defect, and he, along with other children born with this birth defect, sued Dow Pharmaceutical, alleging that the birth defects had been caused by Dow pharmaceuticals from a drug, an antidepressant drug, that their mothers took during pregnancy. You can already tell with a name like Dow and with a serious child birth defect of several children that there's big money at stake. And so, not surprisingly, Daubert was heavily litigated, and that's ultimately how it undoubtedly became the case that became the standard. But I mention this because the sort of expert witness testimony that was sought after in Daubert was one that had previously not been permitted in the courts. Dow Pharmaceutical jumped on this, and they introduced an affidavit from a physician, an epidemiologist, who stated that after reviewing all of the published literature on the anti-nausea drug and related to human birth defects, there were over 30 published studies, there were over 130,000 patients, and no study had found a link between the two. So Dow Pharmaceutical certainly felt that they would win and prevail even at the summary judgment stage. Now, obviously, Daubert, and maybe not so much him, but his attorneys, or the parents and the attorneys for the parents, didn't contest that that was the state of the published research. What they wanted was to introduce 8 experts who had concluded that the drug did cause birth defects, but looking at less traditional drug research. And they wanted to look at animal studies, chemical structure studies, and they wanted to reanalyze previous studies. So I mention this because we have certainly many people here from Dodge County, and we also have the people who are here today. And I doubt that any of us are going to find ourselves ensnarled in a multi-million-dollar birth defect case. But the lesson to take from this is that we don't have to limit ourselves to some sort of academic study to get an expert in. Because what ultimately happened in Daubert, starting first with what happened against the Daubert family, is at the summary judgment stage, the trial judge concluded that expert opinion that is not based upon the epidemiological evidence is not going to be admissible. So essentially that killed the case. Daubert's family couldn't prove from a published study that there was a link between the drugs and the birth defect. They didn't obviously stop there. They went to the U.S. Supreme Court after going through the Court of Appeals, and the United States Supreme Court was called upon to determine what would be the standard in federal evidence rules, and certainly it's essentially now the same in Wisconsin. So our judge is going to be that gatekeeper. You're going to hear that term several times, and that's important to remember what the judge's role is. It's not to decide on the ultimate value or weight of the evidence, obviously. It's also not to determine the science of the evidence. It's to serve a limited gatekeeper function to make sure that completely unreliable evidence is kept out. Perhaps somewhat as a surprise, at least certainly to Dow Pharmaceutical, the Supreme Court ruled that the trial judge must ensure that any and all scientific testimony or evidence admitted is not only relevant but reliable. Certainly that part they wouldn't have an objection to. But the court also said that the court being the Supreme Court explained that the circuit court or district court had to do a preliminary assessment regarding the reasoning and the scientific value and applying the facts to the case. So the court said that you can't simply do the sort of one-stop shop if you don't have the published study, that the evidence doesn't come in, that there has to be the opportunity for the litigants to show that the facts have been applied properly and that the methodology is sound. So the Supreme Court did not create a checklist of what the circuit court must do. It explained that it's a flexible one, and I emphasize that first because one thing we've seen since becoming a Daubert state is people jump right to the checklist. And I think that's a misunderstanding if you don't understand the context with which Daubert came in. And so I start with the language that I think is most relevant, and that is the court is explaining that there is not a definitive checklist or test, that it's a flexible one, and it's looking solely at the methodology and the soundness of the methodology, not the ultimate conclusions. So yes, you can have two experts, one saying that they're going to opine the exact opposite of the first expert. As long as both are applying proper methodology, they both come in. And so it is less about results and opinion and more about methodology. But the reason I start with walking through the facts of Daubert a little more than some people might is when we get to this, what's sometimes referred to as a checklist, you'll have attorneys on the other side saying that your expert shouldn't come in because they're not producing something that has sort of the attestability component, that you're not introducing something that's been peer-reviewed or through publication, or that there's not a known or potential error rate, or that there's not general acceptance in the field. Those 4 items, which sort of kind of form the basis of, for lack of a better term, a checklist, that people might even refer to as a Daubert checklist, certainly do come from the Daubert case, but you've got to remember the context of the case. This is a birth defect, a drug case, so there is undoubtedly going to be lots of sort of traditional academic, peer-reviewed and publications and the sort. When you have that sort of research, you're going to have known and potential error rates, and therefore it's going to be testable. And collectively, through that research, you can determine whether there's general acceptance in the scientific field. The problem is that doesn't work for a lot of the experts that we would want to use in court. If, for example, specifically thinking about the people in attendance in Dodge County, if they want to introduce a domestic violence or sexual assault expert, you're not going to have the same automatic parallels that you have in the Daubert case. You're not going to have the peer review, the publication, at least from a sort of drug testing known error rate standpoint. You will have plenty of academic research in the field, but you're not going to have that known error rate. And so sometimes I have found right after we became a Daubert state that attorneys on the other side would immediately try to argue to the court that we were failing or we were deficient in this checklist. And the proper responses go right back to Daubert, where they're getting this checklist from. And what does the court tell us? That it's not a definitive checklist or a test. And so I think the words of Daubert have been misconstrued, I think sometimes by courts and certainly by opposing counsel, either intentionally or accidentally, by not understanding what was really the issue in the case. And that's why I want to start there. Now the interesting thing is, from that checklist, you might think that the Daubert family would still be out of luck, but the Supreme Court actually vacated the prior judgment and remanded the case, giving the families the opportunity to pursue the case. Now, the court doesn't make the ultimate decision on whether the experts were admissible, but what they ultimately said is they have the opportunity to introduce methodology to try to show that the things they wanted to rely on, the animal test studies and the like, were valid. It didn't ultimately work out for the Daubert family. The Court of Appeals still ultimately dismissed the case. But it's important to understand the context with which that case came about. The points to remember is that prior to Daubert, the general acceptance standard would exclude scientific evidence. So what Daubert actually stands for at the federal level is not so much a new standard that would decrease the admissibility of expert witnesses, but actually one that would increase the opportunity for a party to call an expert witness. It has sort of taken on a different form in Wisconsin, though, because what we have is courts looking to our old rule and certainly seeing that there are more hurdles to cross, which is true. And so it's not a misrepresentation to say that the new Daubert standard in Wisconsin makes it more difficult to introduce an expert. That certainly is true. But to assume that somehow Daubert stands against expert witness testimony is a misrepresentation of the case. It actually increased the admissibility of expert witnesses. And the Supreme Court in that decision really did not like the sort of attack on jurors saying that experts would befuddle jurors. The court found that that was an overly pessimistic view about the capabilities of our jurors. So at the end of the day, Daubert changes, I don't want to say very little, but it changes, I think, a lot less than people thought 4 years ago when it passed. The other critical case to read, and if there's only 2 cases you were to read at the federal level, you really would only have to read Daubert and Kumo to understand the structure, and then you'd want to find fact-specific cases on the type of expert you'd want to introduce. And so what we have is Kumo-Tyer, which came about afterwards. Once again, I think it's important to start with the facts to understand what Kumo-Tyer does and doesn't do when you start to apply it to the type of expert you might want to introduce. So Patrick Carmichael sued a tire manufacturer, Kumo-Tyer, and its distributor after the right wheel of his minivan blew out, which resulted in the death of his passenger. Certainly maybe not quite as much money at stake as we can imagine there was in Dow Pharmaceutical, but certainly a pretty tragic case here. There's the death of the passenger. Now, of course, we imagine Kumo-Tyer, and I'm speculating here, I don't know all the facts of the case, undoubtedly might want to say that Patrick Carmichael was negligent, but what ultimately Carmichael wanted was to rely upon an expert, Dennis Carlson, to allege that the tire was defective. And one thing I want to highlight is that Dennis Carlson was certainly a qualified expert. I think under the old rule in Wisconsin, under the new rule, under the federal rules, no one is challenging that Dennis Carlson is not a qualified expert in terms of his education and training. He has a master's degree in mechanical engineering, years of experience in the tire field. Now, in old Wisconsin law, if this case came before it, we would probably look to the qualifications and quickly assume that Mr. Carlson is going to be allowed to testify for Mr. Carmichael. What Mr. Carlson was going to conclude was that there was a defect in its manufacturing and it caused the blowout, and that it was not Carmichael's misuse, of course, of the tire. Otherwise, we wouldn't expect him to call him. So the issue in the case was less about whether or not the tire was defective or not defective. The issue really came down to how was the U.S. Supreme Court going to apply Daubert to kind of our non-scientists. And I hesitate to say non-scientists because certainly we can take a broad view about social scientists in the field, we can take a view about engineers in the field, and I don't like using terms like hard science and soft science, but the way the court summarized it and saying that they're going to look at non-scientists, I think, can be misinterpreted in what we're viewing engineers or social scientists or other experts we might use. So I look at it as the reason these two cases are very critical is not only the obvious that they're the first two that come through, but they're also important cases, and why I say they're the only two cases you'd need to read before you would want to start searching for facts specific to your case, is that with Daubert, what we have is sort of your classic academic science, studies, peer review, known error rate. And that's where that checklist comes from that I think gets misused and abused in future cases. Carmichael is essentially applied science, which I guess in a nutshell is what the engineers are going to do. He is looking not so much at something that is readily available to known error rates. He's looking at examining the tire, making conclusions about the tire that he then wants to introduce to the jurors. And so between the two, you kind of cover both bases. And the question was, when is a test in the field admissible in court? The U.S. Supreme Court concluded that essentially Daubert's general holding, setting forth the trial judge as a gatekeeper, applies to all forms of expert witness. It is not limited to just scientific knowledge, but it is also the same test that you would apply for technical or otherwise specialized knowledge. So we don't have multiple tests based upon the type of expert. We have one test. The Supreme Court added that a trial court may consider one or more of the factors, that would be the checklist that Daubert mentioned when doing the reliability examination. But that list was only meant to be helpful and not definitive. And so the factors are not necessarily applied in every case. So the best way to rebut opposing counsel who is assuming you have to show a known error rate before, for example, a guidance counselor can talk about child sexual assault is that Kumho-Tyer explains that you don't. In fact, Daubert explains that you don't. And I forget which case, but I think it was Kumho-Tyer actually used the example of a perfume expert who could maybe, or we could think of like a wine expert who might be able to detect scents but can't really quantify that in any sort of numerical value. So both cases explain that we are not going to limit ourselves to one type of expert, but we do have to apply the same rule. So the outcome in Kumho-Tyer is that the Supreme Court concluded that the district court's decision in the case not to admit the expert was within its discretion and lawful, and noting that there were concerns that Carlson really was not so much unqualified, he was certainly qualified, but that he was not able to produce a model or method of analysis of this tire that could be replicated or applied elsewhere. Even in Carlson's report, he referred to subjective and subjectiveness in his assessment, and the court sort of pounced on that and saying that it's not a question of qualification, it's a question of methodology, and that's the biggest thing to remember. It is not so much that a person's going to be qualified as an expert, because their qualifications are the same as always. It's whether or not the methodology is sound. And so, points to remember from Kumho-Tyer is that it didn't involve a question of the qualifications. It ultimately was one where the Supreme Court unified the rule and ultimately confirmed what it said before, which is the circuit court's the gatekeeper. I emphasize this because what Kumho-Tyer did was affirm the lower court excluding the expert. I imagine with the exact same facts and the exact same arguments, the Supreme Court would have affirmed admitting the expert had the circuit court done that or the district court done that. So The reality with our post-Daubert world that we live in Wisconsin is that what you need to do, if you ever have one of these cases, is to litigate it heavily and effectively and not cut any corners in front of the circuit court. Because the reality is there's going to be wide discretion given to the decisions of the lower court. And so it's not going to be the best case to appeal. So getting back to now where we are, or where we were and where we've come, that's the law of the federal land from the cases in the 1990s leading to the change in the federal rule of evidence in 2000. And Wisconsin kept its own rule, and to a large extent was an outlier for over a decade. In 2011, we ultimately became a Daubert state through Wisconsin Act 2 of the special session. The history is perhaps less interesting now since it's been the law of the books for a bit, but it was the first Senate bill introduced that session. Being first isn't always a sign, but it often is a sign that it was probably going to be legislation that picked up quick traction, and certainly it did. It went from being the first bill to the second act passed in a special session. So what ultimately happened is there was a small amendment to the bill, and it's probably less important today, but I emphasize this because the legislation was originally written very similar but not identical to the federal rules of evidence. There was an amendment to change it so that it was the same. And I think that's critical if you are confronting a case on the fact that you can rely on out-of-jurisdiction cases generally for their persuasive authority, and here certainly more so because the language is so identical. However, the language didn't stay the same that long. That very same year in 2011, the federal rules of evidence changed again. So all that work to make the laws the same was a little bit for naught. But the reality is the federal change really wasn't as significant as we think. Once again, looking at the committee notes, it was really amended to create a more easy, workable framework. And so the Federal Rules of Evidence committee note actually said that the changes are intended to be stylistic only and not substantive. So if you're looking and saying, why did this guy tell me the rules are the same and they don't look the same? There was that change. But in reality, if it's an easier framework for you to look at the federal rule, I wouldn't necessarily use that in court because the judge is going to be looking at our state rule. But from a framework standpoint, if this is an easier structure to look at it as sort of a four-part test, looking at the committee note, you're still grounded in the same sort of law federally and statewide. Now, after Daubert had been the law for quite a few years, I just have provided this case for you, U.S. versus 14.3 acres of land, one because it's sort of an interesting name case, but more to the point, what it says is that Daubert didn't work a sea change over the rules of federal evidence, and the trial court's role as gatekeeper is not intended to serve as a replacement for the adversarial system. So we are not really looking at a dramatic change. We are looking at another hurdle being added in the admissibility track, but as long as you know what the hurdle is, it's certainly a hurdle that can be cleared if it was the sort of expert you would have introduced in the past. More often than not, it's the sort of expert you could introduce today. There is not a lot of Wisconsin case law yet. Part of the problem is it only applies to new proceedings. That's not so much a problem, but the reality is even though the law passed in 2011, you have to have the case be charged or issued, and then you have to have it work its way through the circuit court, the Court of Appeals, might end up with a published decision, and then you have the Supreme Court. So we're just starting to see the sort of first wave of Daubert cases come through in Wisconsin. And so we're still speculating a little bit. But what we do know from State versus Giese, I have my same old icon up of the judge as the gatekeeper because that's a phrase you're going to see a lot in the federal law, and now we're seeing it in the state law. So the court's gatekeeper function under Daubert is to ensure that the expert is based upon a reliable foundation and is relevant to the material issues. The key part here, what you don't see qualifications, you don't see those sorts of things because the law is the same before and post Daubert. What you are seeing is the methodology. They don't use the word methodology here, but the reliable foundation is talking about that same prong. And so that's really the issue post Daubert. As I said before, we really can start a Daubert case the same way as we started any case. It is just a series of hurdles that you have to jump through to get to admissibility. And because nothing was removed from the statute, because nothing was repealed from the statute, it was simply in addition to the statute. The hurdles you used to have to cross, you still have to cross. Just remember there's one more at the end. So the first step is almost self-evident, but I think it's important to still emphasize, and that is relevancy. Any relevant conclusions which are supported by a qualified witness should be received unless there is other reason to exclude it. And so I know this might sound elementary that we should start with relevance, but I think when you're really looking at sort of the pseudoscience and you're looking at the weak science, I think sometimes you have more basic issues, and maybe we were too easy in the past about letting that stuff come in. Maybe it wasn't litigated and argued aggressively enough. Frankly, I think that stuff could have been kept out on a lot of different grounds. I've seen a case, for example, where the person was qualified in the field of fire and to a lesser extent explosives, but really it was backyard science. The person wanted to just sort of introduce sort of tests he had run in the backyard. And I think looking back at that case, although it was a post-Daubert case and we argued it on the Daubert methodology prong, I started thinking to myself, why don't we just argue this stuff on the relevance prong? If it's so potentially unreliable, its relevance is certainly weakened. So an expert witness is admissible, once again, this is pre-Daubert law, when the testimony is relevant. That's the point I've just certainly emphasized. The witness is qualified as an expert, and the evidence will assist the jurors in determining the issue of fact. So let's go back to my potential opposing side's expert, who I would concede he had the right qualifications for fire. I would probably question, but might ultimately acknowledge that the court could find that the person was qualified as an explosives expert. But is this sort of backyard science, as I call it, because he literally did the experiment in his backyard, is it really going to assist the jurors in determining a critical issue? And is it relevant? Well, the reality is, the less sound the methodology, the less it's going to assist the jurors. In fact, it's more likely, as we all know from the rules of evidence, you can exclude evidence that is misleading or can lead to confusion. And so that really comes in sort of this third element, and this is certainly a way to keep out experts, and I use that term loosely, who might have testified in the past, and certainly a way to keep out even post-Daubert. So I think we start with where we were. Instead of just jumping into the brave new Daubert world, let's look where we were and realize there's a lot of good case law on these prongs. These prongs have been around for a long time. Nothing has changed with them. And if you have a good case that says something should be admitted or something should be excluded, then if you're trying to get your own witness admitted, work through the old cases. I just use these as examples, partly because of the audience, at least in Dodge County. We are in the public safety building, so when Daubert passed, there was a big fear in Wisconsin that some witnesses used by prosecutors in the past would be kept out. For example, a rape crisis center worker or a school guidance counselor. Well, the reality is we have good case law qualifying those people as experts. Once again, the statute changed nothing on qualifications. So although an opposing side might protest, there was no reason that you're going to have any problem clearing the qualification prong with that type of witness. If you have a case saying this type of witness is qualified to talk about this sort of thing, that's a good case because the qualification prong has stayed the same. Also, just using this sort of sensitive crime area as an example, we have good cases that experts in domestic abuse or experts in sexual assault will assist the trier of fact. So in pre-Daubert law, we had the green light with these type of witnesses, and many prosecutors would use them. There was concern that we weren't going to get to use these people, but the reality is, in a post-Daubert world, those things have stayed the same for the most part until we get to methodology. Does anything not get included in pre-Daubert world? I told you that a lot of stuff came in, and maybe we should have more vigorously challenged some of the weaker experts or weaker science in the past. But it did occur at least in one case that I'm aware of. In Doltzler versus Tuttle, a Nebraska case, they found that a pickup ball expert was going to be excluded because the jurors were perfectly capable of determining for itself whether the defendant was reckless while playing pickup basketball. So I offer this example. It's a little silly, but it's noteworthy in saying, have we cleared our old Daubert prongs? Does this actually help the trier of fact? Is this something that's common knowledge? Can we assume the jurors are going to know the basic rules of pickup basketball? And if so, maybe we don't need a basketball expert. I doubt you're going to be seeking one of those in any case you have, but the concept is still sound, which is let's step back and not fear Daubert. Let's just step back and say, why do I want to introduce this expert? What is this expert going to do for me? And most importantly, not what is it going to do for me, what is it going to do for the jurors? Where are the deficiencies where an expert strengthens the case? So we're about midway through the presentation. I'm going to take you right back to where we began. Because although our statute is long and wordy, it can be broken up into a series of parts, and I think that's helpful. Assisting the trier of fact and being qualified as an expert are, as I've said repeatedly, and I want to emphasize this, have not changed under the statute. So those are prongs that stay the same. What has changed is this additional language. So we have to go beyond where we were to understand where we're going. And so in a post-Daubert world, experts are admissible when the expert is qualified, which we know is the same, and jumping ahead to the third point, when it will assist the trier of fact. So at least using the three-part test that Kilpatrick has sort of created, which is an 11th Circuit Court case, it's really ultimately this prong. The only thing that has changed in Daubert is we have to show that the methodology used was reliable as determined by a Daubert inquiry. And I'm not going to tell you here whether you should use a 3 or 4-part test. You know, the Federal Rules of Evidence has been amended and created an A, B, C, D, and maybe that's an easier framework. Eventually we'll have a Wisconsin case that breaks it down into 3 or 4 parts because courts tend to love 3 and 4-part tests. But what's important for each of you, if you're ever going to introduce an expert, is that you find a framework that works for your case and that you don't ignore a step. I think in the past we were too lax with the sort of documents we filed in the court, and Daubert really forces us in many ways to do what perhaps we should have been doing in the past. But in terms of the legal issue, the only legal change is this middle prong, which is sort of memorialized in the B, C, and D part of the new Federal Rules of Evidence. So the testimony is based upon sufficient facts and data, that it is based upon reliable methods, and the last one, which I'll emphasize a little bit later, that the expert reasonably applied the facts to the case. So if we look to Wisconsin law post-Daubert, what we're going to have is the same sort of things that we just saw in the federal case. So questions we're going to want to ask when we get to methodology is the expert's theory. Can it be tested? Has it been tested? So let's go back to the example I gave earlier about a sexual assault case. And a prosecutor wants to introduce an expert that says victims of sexual assault typically do not report right away. And the defense wants to introduce an expert to say that there's a high rate of false reports in sexual assault. So the first question is, can either of those expert theories be tested? Can we test the first theory that victims of sexual assault are not likely to report right away? We certainly can. It's not much different in many ways than Daubert, where they looked at 130,000 patients. We can look at studies that have said, we've examined, in one case, 100 victims of sexual assault, in another case, 5,000. There are sometimes studies of studies that could say, after looking at 25 studies, including 50,000 victims of sexual assault, we find that victims fail to report right away in, I shouldn't use the word fail to report, that's can imply victim blaming, but we could say victims do not report in 75% of cases. And you're probably going to have a range, right? You might have one study saying it's X percent and another study saying Y. And so sometimes these studies of studies can be helpful in giving you that range. So is that a way you could test your expert's theory? Yes. Now let's say we look to the opposing side who wants to introduce an expert who says victims fail to make false reports. As a general premise, can we assume that there are failed reports in some cases? Sure. Can we also then go further and look at what the studies say? So we can do the same thing, right? Some studies might say it's 3%, some studies might say it's 5%. There might be some outlier that says it's 50%, right? We imagine the defense expert might latch onto that study. So in both cases, that's sort of the first step, though. can we take the overall premise? This witness is testifying to prove point A. Is there a way we can test, or has point A been tested? And you can see just from this sort of real world, non-pharmaceutical, multi-million-dollar case, which doesn't involve sort of the standard drug testing, it's very easy to use social science to test the defense and prosecution's expert. The next Daubert inquiry, this kind of comes from the checklist, is has it been subjected to peer review and publication? Well, let's take the exact same example and just go a little further. I just gave the example where we could certainly look at studies of studies, we could look at publications, and all of those things would be in peer review sort of sources. Many of them might be in non-peer review sources. So just keep a mind out for what type of source you might want to rely upon or what your expert might want to rely upon, but certainly both could be the subject of peer review and publication. This gets a little trickier when we look at the checklist that was created in Daubert of the known or potential error rate. The best you could probably do here is look at sort of the study of studies or show the range. But you could certainly at least offer some information about the methodology in a macro sense, and then sort of how it's being reported in an individual sense. And then ultimately you get to the technique and whether it's generally accepted in the scientific community. And remember, by science I don't mean just the academic sciences like medicine or biology, but more broadly in the social science community, can you find certain premises? So is it true that we're probably going to find that there's general acceptance in the community of social scientists that victims typically wouldn't report right away of a sexual assault? The answer is yes. And what about a false report? We would probably find that the general acceptance is that it's a very low rate. There will be some outliers, but overall we would expect it to be in a lower rate. So if an opposing side is introducing an expert and they're attaching an academic study, but it's really this outlier, you might have to concede that it's peer-reviewed publication. You might have to concede that it can be tested and has been tested, but it might ultimately fail on that general acceptance prong. So there's a variety of ways you can actually use this sort of Daubert checklist against your opponent's side, just as you can have it in your pocket for when you're introducing it. But remember, at the end of the day, these are a guide and not the definitive checklist. So the practical implications for Daubert is that the new law should not prevent the use of experts in areas where experts have been previously used. And to a large extent, I think that's true. Because the way it helps the jurors haven't changed, the qualifications haven't changed. But what I ultimately think Daubert does in a practical sense is that there's more work required on the front end before you get to trial. I think because so many experts were introduced in the past, there was sort of a general feeling that it wasn't really something that was going to be heavily litigated at the pretrial stage. That's not maybe true in every county. But what we now know is that you can't take anything for granted, that certainly the burden is on the party who wants to introduce that expert to meet the criteria. And so if the legwork is just done on the front end, you're in a better place preparing your case, and you're in a better place having that expert ultimately admitted. So it's less about excluding experts and to a large extent about preparation. Because frankly, if your old experts were relying upon bad methodology, it was probably an expert you didn't want to use. And if in the past your expert was using good methodology, it probably was worth the extra time to find out what that methodology was. Because whether or not you introduce every last point to the court or the jury, it's going to make you have a better handle and control on your expert and what they can and can't testify to. And on the flip side, if you've attacked weaker science from your opposing side at the pretrial stage and prepared it, but the judge still lets that person in, your cross-examination of that expert is going to be that much better. And so the practical effect, from my experience and my looking at this, is that Daubert it's sort of forced homework for the attorney. You're going to have to do it now instead of wait to do it later. Now, you remember early in the presentation I talked about qualifications, and research, and application. When we look to the qualifications, those are the same. Ideally, you'd want to find a case maybe that has used an expert like you've used in the past. I gave case sites for things such as school guidance counselors, rape crisis workers, certainly domestic violence or sexual assault. workers who would have the qualifications, but you're going to run into situations where the expert you need hasn't come through in a previous case. The best thing you can do is look for a similar expert. Maybe you can look for it by career. Is it someone in the engineering field, someone in the medical field? Is it someone in the law enforcement field? The other way you can look for it is maybe more fact-specific to your case. But ultimately, you're going to typically find a case in Wisconsin, probably pre-Daubert, but one that you could use to show that the witness has the necessary qualifications. Remember that it is not just education. It can be knowledge, it can be skill, it can be experience, it can be training. And I really don't want to, bore the court with every little prong, but it's worth thinking about what is the qualifications of this person? Am I relying on them because of their education? Do they have the PhD? Do they have the master's degree? Do they have the BA or the BS? Do they have an associate's degree? Am I really relying upon them because of their knowledge? Or is it more because of their experience? And so you want to look at kind of collectively. Sometimes we just use laundry lists in the law and you just jot down, this witness is qualified based upon knowledge, skill, experience, training, and education. Maybe a more prudent approach would be to say, this person is being introduced because they have the necessary education, which they have used through their experience, and have continued to hone with training. And you're telling the court that you're not being sloppy, that you're actually focusing on the words of the statute that matter most to you. The second part is the research. The expert opinions must be based upon the methodology and the sufficient facts. That's the new material that Daubert gave us. So certainly that's something you want to hone in on. I think the best place to start in terms of getting what you need in court is with your expert yourself. The expert should be able to tell you in a general sense what their methodology is. Is it something they've gained through years of working in the field? Is it something they've learned academically? Have they learned it at conferences or workshops? Depending on the type of expert, you might be fine with just what the expert provides you. There are times where you're using a person who's maybe never been an expert before in court, and you might have to work with them a little bit longer on developing methodology. They still are the ones who are going to have to be able to justify that methodology. But it is worthwhile, if they've never been an expert before, only been an expert once or twice, that you sort of walk through what it means legally. It's not your job to tell them factually what to say or do, but they're not going to understand the legal standard and the legal implications, and so it is worth you being the buffer between what they do for a living and what the court or what the statute wants to see. And honestly, that's where I've spent most of my time in a post-Daubert world. The application, I think, gets sometimes forgotten, but it is also part of the new statute, and that is the expert reliably applied the principles and methods to the facts of the case. Usually that's self-explanatory. If the expert has submitted the necessary documents for the court, and you've got the methodology, and you know what the facts in the case are, you sort of often know that they were applied to the facts in the case. However, there are times where I think this is the basis of a Daubert hearing. I think that Daubert hearings, and don't ask me to give you stats on this because I'm only speaking from anecdotal experience, I think right after we became a Daubert state, if the side opposing the expert asked for a contested hearing, courts often gave it to them almost on its face. That might not be true in every county, but it was certainly true with many judges. I think that may not still be the case today, because if for example, a police officer has done field sobriety tests repeatedly and it has been validated in case law, you don't necessarily have to come back to court every time to have the judge hear from that officer, especially when Daubert's about methodology, not about so much this witness, but more about the underlying science of the field sobriety tests. But the reason I bring up the example of this field sobriety test is if a defense attorney said, Your Honor, we had that probable cause hearing, and he said he held the pen out further away than his manual said, I'm not contesting the methodology, but I'm contesting whether or not that expert reasonably applied that principle and method to this case. It might be used as a fishing expedition, which certainly would be an improper reason to use the Daubert hearing, but I'm frankly surprised I haven't seen more challenges on the application. I think there would be a clever way for an opposing side to say, look, we're going to concede methodology. We want that expert in here pre-trial because we have to make sure that after this methodology, that expert applied it properly to the facts of the case. Now, the officer field sobriety example is a little bit trickier because that is a person who's both an expert witness because of their training and experience, but also essentially a lay witness for what they did and saw in the field. For a detached expert, it might be a little more difficult to make that argument, and it might be something that could be handled through supplemental materials provided to the court.
Wynn, can I interject for just a second? Is there presently a challenge in either the Court of Appeals or the State Supreme Court to the HGN standard field sobriety test on sort of a Daubert ground?
There was a case I heard about, quite honestly. I don't know where that's at in the process.
Okay, so you want to know whether they're challenging the sort of the subjectivity of the test, sort of, which was the problem that Kumo Tire's case, or whether they're objecting to some other prong?
You know, they could object to the underlying science, and for being an appellate challenge would be more in that realm. But quite honestly, I don't know where that's at. I know there was, probably of all of the field sobriety tests, the HGN was the most litigated. But a potential resource would be Tara Jenrud's, who is the traffic resource prosecutor. She'd be more in tune with where that case is at, or case is. But I know that was, in the OWI realm, that was certainly my understanding of the most litigated pretrial Daubert issue. One thing I have encouraged experts in the past, since Daubert, is to work a little harder on getting the kind of background material to me, the qualifications. Even though I've said the qualifications haven't changed, we're still in a world without a lot of post-Daubert published case law. We also know that the standard to overrule what the circuit court judge does to admit or deny an expert is going to have somewhat of a limited review. So it's important on the front end to make sure that you're not cutting any corners. When I've dealt with experts who are regular or repeated experts in court, I don't need to walk through this with them. You know, they've often testified many a times. Some of them have testified many times in federal court. I don't need to walk through and explain what I need for their professional background or their CV, which is just a fancy resume. But I have, when I'm dealing with kind of the person who's based upon their experience in the field, someone who maybe has a career in a field and has been in that field for 10, 20 years, but is not a regular and repeat expert witness in court. And frankly, there's no reason an opposing side couldn't raise a Daubert challenge to a physician or a doctor who may not have their CV dusted off, but I just haven't run into sort of the doctor challenges. But don't assume any particular witness is going to have the qualification prongs for you. Even though it hasn't changed, I think it's helpful to work with your expert to make sure they have a CV, that they can give you a background, and just put that included in with any pretrial filings. A CV is a living document. It should be updated frequently. So find out, what version you have, when it was last updated, because the opposing side is going to jump on that document. If it looks like they've had no training in the last 4 years, but it was really just that they haven't updated it in the last 4 years, that is going to be a point that is jumped on by the opposing side. So talk to your expert, and that's the point I have to really emphasize enough. In different fields of law, it might be a little different. I can certainly say in prosecution where there's high volume, that the conversations that really should ideally go through with a prosecutor talking to an expert pre-trial, in reality don't always occur. But the reality is it's only going to hurt the likelihood of the witness being admitted, and it's going to hurt the ability to use that witness very effectively. The research, this is the methodology, the prongs of Daubert, is certainly comes from a variety of sources. I use social science as just an example and give some citations because that's where I think it often is the most gray post-Daubert. I think in reality not much has changed, but I think people sometimes are expecting or looking for that kind of academic scientist. And you might have the PhD in psychology or sociology, but more often than not, you're going to have someone who's working in the field. And so it might be a long time since they have read academic books or social science. So I offer a cite here that it could be from a variety of sources to verify. And the interesting thing that I think gets lost in Daubert too is Daubert is a methodology challenge essentially. So many times your expert may not be the best person to prove the methodology. They might know it because they've been doing it in the field, but they aren't always your methodology expert. And so I'll talk a little bit about how you can bolster it on your end as an attorney. And that's really doing a little bit of simple research, just kind of walking through the different areas where you might be able to find the materials you need. Trainings, conference materials, all those sorts of things can be places for information. And so what you can ultimately do, I offer here is just sort of one example. Once again, I don't want you to put words or methodology in your expert's mouth, but I think it's important. You're just going to be better at your job if you understand what they do and what they know. And so I just offer as one sort of source here, Badger link, and I'll come back to that in a moment. One thing I did, perhaps I did it too often in the beginning, but I wasn't sure what kind of challenges I was going to get, is I went very heavy on methodology, and I would use the learner treatise. And I would just introduce my notice of expert. I'd have their CV. I might have a summary of what they're going to say. And then I would use and dust off the old learner treatise statute. The only problem is it has to be 40 days before trial, so there's some time limit implications. But sometimes I would just prove the methodology by a series of studies and leave it at that. I've got 5 studies here, Your Honor, that says victims of sexual assault delay report, and that it's common. I proved the methodology, and I proved it by learned treatise. So we don't need a Daubert hearing. I moved a little bit away from that technique simply because I think it was overkill. But in the beginning, I didn't know how the various judges I was appearing in front of were going to respond. So coming back to BadgerLink, just where you can do a little simple research at your desk. This is a state database. I think it's through the Department of Public Instruction. And I don't know what we pay currently, but you as a taxpayer are paying lots of money for this website you're never using, perhaps. And what it really does is, we all know there's the internet with tons of great resources, but there's the whole hidden internet, and that would be password protected, copyrighted material that they don't want to disclose. So if you try to find an academic study and you find the name of it and you search the journal site, oftentimes you'll just get a little prompt that says, enter your username and password, are you a member? And you're not going to subscribe just to get this one article. And the good news is that the state of Wisconsin has a subscription to not all. This is far from a complete list of databases. So I don't use this as my end-all, be-all, everything is in here source. I use this as, if it's a generally accepted premise in the scientific community, one of the databases they pay for is probably in here. And so you can just enter BadgerLink. I know you can't read it from there. But if you click on the All Resources and you just sort of scroll down a bit, the All Resources list is a good database to kind of have more rather than less, and you can just enter something here. So I entered delayed report, in quotation marks, sexual assault. And what pops up, but right at the top we have, sometimes you get just a synopsis of the article. Sometimes, depending on the subscription, you get the complete PDF version of the article. And it's for free because it is actually being paid for. It's not pirated material. But you're getting the state to pay for the subscription service so that you can pull up these articles. I think the service has changed from time to time through the years. You may have to enter your library barcode or enter it through your library site. There was a time where I think if you just had an internet address in Wisconsin, you could access the site. So if you run into an obstacle, you can probably access it through the library, but you can still do it from home just with your library card. And I sort of just use this as my little quick check. Am I way off base on what I think the methodology is before I call my expert up? So the ultimate application, we talked about a little bit. I think there's still some gray area about how much this is going to be challenged. But remember, you could do everything right with qualifications, and you can do everything right with the methodology. But we still have to make sure that it was applied properly to the facts of the case. This is usually self-evident, but I think there's some opportunity to keep out experts from opposing sides, or to face a challenge where you're now stuck in a Daubert hearing you tried to avoid. But ultimately, still kind of focusing on practical implications. If the court is satisfied with the education or the qualifications, and it's based upon educational and training, then the court is going to admit that expert, and that's the best point to take here. I offer this as sort of a parting thought. I said there's not a lot of good published Wisconsin cases, so I come back to State v. Giese, which kind of confirmed what I thought the state courts would start to say, which is very similar to the feds. They picked a rather unusual metaphor, though, where they said that Daubert is both flexible, but it has teeth, because I'm not familiar with what flexible teeth are. But what I imagine they mean is that the courts should be flexible in its application, but attorneys should realize that if they are not going to go through the steps at the pretrial stage, there's going to be some teeth to the consequences. They're not going to ultimately be able to get the expert in. And so gatekeeping function is a critical sort of buzzword of Daubert, flexibility in exactly what you need to show. But ultimately, that's not an excuse to not sort of do the front-end work. And from there, you're going to be able to successfully get your experts in.
Well, that will formally conclude the program. I think we're over the 50-minute mark, and so thank you so much, Wynn, for your time. Now, for those that have to get on to other matters, certainly they should feel free to do so. But do you have maybe 5 minutes for any follow-up questions, either from Dodge or from here in the room? I guess because we're here in the room, let's start here first. Anybody in the audience have any follow-up questions on any of the material that was presented? You were talking about, I think, error rates, and then also there was sort of a prong that dealt with the generally accepted in the scientific community. I think you sort of alluded on that latter point just a few minutes ago. Your own expert probably wouldn't be the person that you would use to say whether the methodology is generally accepted in the scientific community. You'd have a second expert come in and talk about that. And what does that look like?
That can get expensive, and that's the problem.
Yeah.
But it is certainly conceivable that the expert you have, I mean, I'll be practical here for a moment. There might be times you want an expert because of geography, because of cost, because of how they're going to relate to the jurors, but they're not going to be the person who really talks about methodology. From my experience, having gone through a few Daubert hearings, but certainly not where I can speak more broadly, because we just don't have the case law, locally on it in Wisconsin, I have found typically that I can get over that methodology prong by doing things like the learned treatise, or by confirming with my expert, okay, you're saying it's delayed report. Here are the numbers I'm finding. Are these consistent with your experience? And so rather than bringing in a methodology expert, in a world of unlimited resources, it might be worthwhile, but practically speaking, I've used the articles as a way to kind of forego that. When I have an expert who maybe is qualified because of experience, but not qualified because of education.
Mm-hmm. But what if you were to, I mean, again, this is not an area that I have any expertise in. If you had two competing learned treatises, I mean, how would that work? I mean, because it comes in as an exception to the hearsay rule, and I can see somebody on the other side saying, well, that's not the right learned treatise. My learned treatise says the exact opposite of what his says.
I'm probably stretching the learned treatise, because, I mean, that's for introducing it at trial, but I've used it really as a pre-trial resource, and sometimes I've worked out with the opposing side what we aren't going to admit. I mean, there's the practical problem that, great, I've got it in through the rules of evidence, so we now put a pile of paper in the exhibits, and the jurors are going to sit back in the jurors' room not knowing what that's about. So, I've used it, and like I said, maybe in some respects I'm using it more for pretrial purposes, but I've not run into a major problem with courts or with opposing counsel when it comes to, okay, I did this for methodology, here's what I want the witness to say. And there's times where we've either said these aren't going to be introduced, and I'm oftentimes, rarely is the other side going to get upset with you when you don't want to introduce something you filed. They falsely assume that it's some great gem and that's why you filed it. Because I don't necessarily want that battle with the jurors on paper. I'm okay with the battle between the two experts, and they can hear from one and you can impeach one. And just practically speaking, maybe less legal and more practice, I haven't run into that problem.
Okay.
In terms of competing learned treatises at the admissibility stage, to a large extent, that is perhaps an argument for both things coming in. It's an oversimplification, but certainly if both are peer-reviewed, there's a good argument that maybe both should come in, and it's something that has to be ferreted out. But more often than not, the kind of macro, big-picture methodology is not stuff that I've ever run into a problem. I mean, even experts who you think the other side is sort of the hired gun will often, if they have the right qualifications, will come around to kind of conceptually the big picture issues. We might disagree on what the rate of false reporting is, but we're not going to be 50 percentage points removed.
Any questions over in Dodge? Guess not. So I guess that will formally conclude our program. Thank you, all attendees. Thanks once again to our guest speaker. Let's give him a round of applause. He's not getting wealthy by being here today. So, all right, I'm going to disconnect.